Thank you, Mr. Chairman. We have two competing narratives here. We have 5 witnesses and 2 opinions. 3 witnesses believe that it's within the power of Congress to act. 2 witnesses believe it's a violation of separation of powers. We have a dispute here and disagreement among basically Republicans and Democrats about what the motivation is of an ethical investigation, whether it's just a proxy for the competing views about what the outcome of the decisions were. I happen to strongly believe that the Congress does have authority, and I won't rehash that. But I would ask this: wouldn't it simply be wise for the Chief Justice, who is the steward of the public reputation of the court, on his own volition, to adopt a strong code of conduct that the court would adhere to? Attorney General McCasey.
Want a one-word answer? No. Because the strong code of conduct that you hypothesize would then have to be enforced with a mechanism that would involve the questioning of individual justices. He has in his letter to this committee, he has outlined the procedures that are used in cases of recusal.
So let
me
ask
outlined
this.
The fact that they file the same disclosure reports that other judges file.
So if he had a code of conduct that included a Supreme Court justice cannot take a bribe, something that they can't do, you would say that would be improper because they would be subject to enforcement outside of the court?
No, I would say that would be redundant because they are subject to the same laws of general application that apply to federal employees. They could be prosecuted.
Thank you, Mr. Payne.
And they could be impeached. That's not the same question.
Thank you. Do you have a view as to whether it would be prudent for the Chief Justice of the Supreme Court, as the steward of its reputation, to promulgate, or pardon me, I'll ask you, Mr. Dupree, a code of conduct that would apply to all?
I think the Chief Justice, at least Justice Kagan, when she testified before the House several years ago, she said that the Supreme Court was actually considering doing that. They obviously haven't done it yet.
I'm just asking, as a citizen, we have different points of view. But what is the problem with the Supreme Court justice saying, let's have a code of conduct that applies to all of us?
I think the problem, at least the potential problem, would be the one that Judge Mukasey identified, which is to say, what is the enforcement mechanism? Is there going to be some superior tribunal to the Supreme Court that is going to disqualify the justices?
The average Vermonter. But I want to go on to another issue. There's been discussion that there is an agenda here because many on our side disagree with some of the court decisions. Let me just admit, I am one of those who disagrees with a lot of the court decisions. We've talked here about separation of powers, which I agree with, but we've also talked about checks and balances. And my view is that the erosion of support for the court has less to do with the ethical issues and more to do with a public sense that it has completely disregarded the rights of the majority through their elected representatives to pass laws to protect the public interest. Now, I'll ask you again, Attorney General, the Supreme Court has done this before, in my view. The Dred Scott decision, they said African Americans couldn't be citizens. They said Congress could not legislate against slavery in the territories. And historically, do you agree with that decision?
With Dred Scott?
Yes.
Hell no.
Good. But that was the court interfering with the authority of Congress to legislate on what was a majority point of view to start pushing back on slavery.
That was the court making a disastrous
That's correct.
error.
And in the Bruin decision, which was where the New York legislature was attempting to protect its own citizens from the violence of rampant gun violence, the Supreme Court said they didn't have authority to do that. And that is completely divorced from what the majority of American citizens want about gun safety. What say you about that?
What I say about that is that the Bruin decision stands on its own rationale, and it does not have to do with denying anybody's rights or denying anybody's
It
protections.
denied the legislature the right to protect the citizens who elected them.
What it
What
says is-
about
what it
the
says is-
Lochner decision? No, let me ask about the Lochner decision.
Which has been overruled.
At the beginning of the progressive era. Yeah, it was overruled, thank goodness.
By the
But
Supreme
at the
Court.
beginning of the at the beginning of the progressive era, the court, according to Holmes, who I happen to think was a pretty good justice, and he was a dissenter, said that what was the rationale of the court's decision prohibiting the New York legislature from protecting the workers from working 60 hours a week, that was based on the court's adherence to not a legal principle, but to an economic doctrine of laissez-faire. Do you agree with that decision?
With the dissent or with Lochner?
With the basis of the decision where the court essentially interfered with the legislative capacity to pass laws, in this case, to protect against abusive wage and hour regulations imposed by the employer.
I don't agree with it, and more to the point, the Supreme Court didn't agree with it because they reversed Lochner.
But here's the point here that I want to make, and I appreciate your pushback here. The checks and balances component of the Constitution is being disregarded. The Congress is not autonomous. We are all elected and we reflect different points of view. But this Congress, as in the Lochner Congress, as in the Dred Scott Congress, has the authority and the responsibility to act on behalf of the citizens who elected them and not have that impeded by a Supreme Court unless there's something unconstitutional. The decision-making authority of the court, we're not contesting. I yield back and I apologize for going over my time.